Good day, Crime Talk aficionados. This is Scott Reisch from Crime Talk, and thank you for watching. We have a busy docket, so let's get right to it. First, a new search warrant executed on the Lori Vallow case. Second, you, the viewers, had questions regarding the Letecia Stauch case and the charging documents. I will explain them. Third, a man in Florida lets a 12-year-old drive. Fourth, Michael Avenatti still can't have the internet. And finally, our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. There's a lot of breaking news in the Lori Vallow, Chad Daybell matter. By the time we go live at 6 p.m. Mountain Time today on both YouTube and Facebook, will Chad Daybell be in custody? Be there at 6 p.m.? Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thanks for watching. If you have not already done so, hit that subscribe button, leave us a comment below, hit that little bell over there in the corner so that you receive notifications of when we go live, like we'll do this evening, or when we put out new content. First on the docket, a new search warrant was executed in the Lori Vallow case. Well, what could the police possibly been looking for? Well, the Rexburg Police Department on Tuesday morning announced that it was serving a search warrant on the home of Chad Daybell. As you may recall, Chad Daybell is the fifth husband of Lori Vallow Daybell. We try not to put the Daybell with the Vallow because we're not sure how long he's going to be around. Bottom line is the police executed a search warrant. They are not disclosing the contents of the search warrant. It remains sealed. Additionally, spokespersons for the Rexburg Police Department said that they are not going to tell us what they were looking for. Now, there's been some photos that have been released from a helicopter above the search area that included the home as well as the large yard surrounding the house. You can see the police put up tarps so that people, in helicopters can't see what exactly they're looking for. It's unclear what, if anything, the police actually took from the residence, but as we've talked about before, you don't get to go just rummaging around when you execute a search warrant. You have to have probable cause to believe that there is something of evidentiary value, and the police have to articulate how they came about this information and why there is some reliability to it. They can't just go start digging up a residence without that information. Now, just so we're clear, this is a little speculation on my part. My guess is that something was said on the telephone calls that were being monitored. We're not talking about the mistaken calls that were being monitored accidentally that may have been attorney-client. I think they were probably telephone calls that were monitored in the normal course of the business that takes place at a detention facility where it clearly states these calls are monitored. We will see if I am correct. That's just my hunch in this particular case because, well, that's usually where they get the best information because people cannot resist about talking about their case while they're in custody. Happens all the time. I beg clients not to do it. Then I get new discovery, and it always is the jail calls, and they're talking about the reason why they're in custody, and it's usually not good. So we'll wait and see, but clearly some action taking place. Chad Daybell has not been charged with the disappearance or death of either JJ or Tylee, and obviously Lori Vallow has only been charged with the desertion of the two children. Nothing as it relates to their death because no one has been able to confirm that they are in fact deceased. We'll continue to follow this case. Like I said, this is one of the more bizarre cases that I have observed in a long, long time. Next on the docket, the Letecia Stauch case. For those who aren't familiar with that, Letecia Stauch is charged with killing 11-year-old Gannon Stauch. Letecia was the stepmother. Originally, when Letecia Stauch was charged and ultimately arrested, there was only one count of murder in the first degree. An amended complaint was filed, and it lists 2 counts of murder in the first degree. When we rattled off all the charges against Miss Stauch the other day, a lot of subscribers had questions about why are there 2 counts of first-degree murder? Well, let me explain. It is called alternative theories of prosecution. All right. So as we discussed in yesterday's video, there's 2 counts of murder in the first degree, and 1 count of child abuse resulting in death. Count 4 is tampering with a deceased human body. Count 5, tampering with physical evidence. And counts 6, 7, 8, 9, 10, 11, 12, and 13 are what they consider to be sentencing enhancers, which we'll talk about on a later show. Today, we're only going to talk about counts 1 and 2. And count 1 reads, on or about January 27th, 2020, Letecia Stauch unlawfully, feloniously, and after deliberation, and with intent to cause the death of a person other than herself, caused the death of Gannon Stauch in violation of Section 18.3.102, paren 1, paren A of the Colorado Revised Statutes. That's count 1. Count 2. On or about January 27th, 2020, Letecia Stauch unlawfully, feloniously, and knowingly caused the death of Gannon Stauch, a child who had not yet attained 12 years of age, and the defendant was in a position of trust with respect to the victim in violation of 18.3.102, paragraph 1F of the Colorado Revised Statute. So what does that really mean? Could Letecia Stauch be found guilty of both counts? Yes, she could. Would she get multiple life sentences? No, she would not. At sentencing, if she were convicted, and obviously she's given the presumption of innocence as we sit here today, but those counts would merge. So, jumping back to count 1 again, on or about January 27th, that is when the people are saying that Letecia Stauch allegedly caused the death of Gannon Stauch. They would have to prove that it was done unlawfully. Unlawfully means without legal permission or justification. Feloniously, that it's a felony punishable by a possible penalty in the Colorado Department of Corrections. After deliberation and with the intent to cause the death of a person not herself, specifically Gannon Stauch. Those are the elements of the offense. Count 2, murder in the first degree. On or about January 27th, Letecia Stauch, once again, unlawfully, feloniously, and knowingly caused the death of Gannon Stauch, a child who had not yet attained the 12 years of age. So as you can see, in count 2, the elements are that she caused the death of Gannon Stauch knowingly, knew what you were doing, aware of your conduct, practically certain to cause the result. But it's not after deliberation. And it's saying that Gannon was under 12 years of age. Obviously, the Colorado legislature put that provision in there because we don't want people going around harming children. Additionally, one of the elements that they have to prove is that she was in a position of trust. A position of trust is a caretaker, caregiver, a parent, a step-parent, anyone basically watching that child. And if they knowingly caused the death, then that's how that would take place. So a jury, assuming the prosecution lays out a case and presents some evidence to each and every element of those charges, the jury would get the opportunity to deliberate on those charges. The jury would also get the opportunity to deliberate because the defense will more than likely request what they refer to as lesser included offenses. So second-degree murder, criminally negligent homicide, reckless manslaughter, which carry less severe forms of punishment. The question then becomes, the jury can find Ms. Stauch guilty of both counts 1 and 2, but at sentencing, she would only receive 1 life sentence if she were found guilty of that because the counts would merge. You're not going to have consecutive sentences for the different theory of prosecution with the same victim. Hopefully that makes sense. If not, let me know and we'll try to explain it better next time. Quick sponsor update. We have a new sponsor, and that is the makers of the TC1200 Pro Tactical Flashlight. Go figure, right? This item makes complete sense. I have 2 of these. I keep one in the house and the second one in Crime Talk 1. You never know when you're going to be out and about or have an emergency with the airplane, or you have to, if you get off late, you need to do your walk around. It's nice to have a good, bright flashlight there. Second, always keep one at home. These things will light the entire house up like a Christmas tree if there were any sort of issues. We had a power outage the other day. Huge windstorm came through. We were out of power. We had a power outage for about 6 hours. What did we do? The first thing we did was pull out the TC1200 tactical flashlight. Now, go to crimetalksearch.com/1TAC. We'll put the link up to it. This is great for everybody. You can put this in your car, keep it in your glove box. You can put it in a purse, a backpack. You can keep it anywhere. It's light, it's durable, it's not going to break, and it's going to be there when you need it. And it makes a great Father's Day gift. Order now so you make sure you get it in time. Go to crimetalksearch.com/1TAC. Order your flashlight today. Next on the docket, a Florida man lets a 12-year-old drive his SUV. Sean Michelson, a Florida man, is facing felony charges after letting a 12-year-old girl drive his SUV. Now, he also told the young girl that if they were basically stopped, that he was her father. That's not so. In fact, when the 12-year-old spoke with the police, she thought it would just be cool if she could drive his car. And apparently, Mr. McMichelson was drinking, so maybe that contributed to the poor decision-making process. Apparently, the Jeep was pulled over doing 85 miles an hour in a 45-mile-an-hour zone. When asked by police why she was driving so fast, she said that Mr. McMichelson told her to do so. Mr. McMichelson is being held without bond, but he obviously is going to have some explaining to do to the court as to why he would allow a 12-year-old, not his daughter, to be driving the car. There may be additional charges if Mr. McMichelson had provided alcohol to the minor as well. Next on the docket, Michael Avenatti. You remember him, right? He rose to fame, big celebrity lawyer, and then things came crashing down. He was indicted basically for extortion in New York and ultimately convicted. He was in pre-sentence confinement and then detention awaiting sentencing in New York. However, the judge felt sympathetic and released Mr. Avenatti because of the COVID-19 crisis. What did Mr. Avenatti do? He immediately returns back to California to reside at the residence of a friend so that he can prepare for his other case currently pending in California in U.S. District Court, where he's charged with stealing lots of clients' money and a sundry of other charges. Well, apparently one of the provisions in the pretrial release order was that Mr. Avenatti is not to use the internet in any way. As you may recall, Mr. Avenatti was a huge fan of Twitter. Well, he can't do that. Well, the prosecutors in the case have said that Mr. Avenatti must have filed several documents on his own, which would have obviously required the internet these days. So the judge wrote a 3-page order clarifying that Mr. Avenatti is not to use the internet on his own. He can only access and use a computer to review the discovery in his case and nothing more. Additionally, he put the burden on the defense counsel to assure that Mr. Avenatti and the computer that he is using has net disabler software on there, and that basically they have to provide verification to pretrial services when that is done. Obviously, a lot of people don't trust Mr. Avenatti. Now, he is a convicted felon. Of course, that's subject to appeal. However, he has been convicted of the extortion case against Nike. You know, that's where he asked for a settlement for his client and then thought, for a nice little, what was the word he used? Compliance. He was going to conduct a compliance program for Nike at a small fee of like $25 million. Of course, his client wasn't going to get anything of that. That was a separate deal that he negotiated for himself. A jury promptly found him guilty. We'll see how sentencing goes. Sure, it's not going to go well, particularly after his trial in Southern California. We'll see how his trial go. We'll see how his sentencing goes back in New York after his trial in Southern California ends. Next on the docket, our dumb criminal contestant of the day. This dumb criminal contestant story begins in South Carolina, Myrtle Beach specifically, and it was going to be a birthday bash. But what we can tell is 2 is a couple, 3 is a crowd. The police responded to the La Quinta Hotel in Myrtle Beach, South Carolina, after a 911 hang-up call. When the police arrived, they spoke with the birthday girl, who said that she had invited a 19-year-old male friend to spend the weekend with her. The woman who was celebrating a birthday, her name was Mary Jane, and she invited Jahim there as well. Now, apparently, Jahim showed up early with somebody else. We don't know that third person's name. However, apparently, Jahim started to engage in a little pre-birthday celebration with the unidentified woman. Apparently, there was some sort of an agreement between all 3 to engage in sexual relations. As things got going, Mary Jane allegedly pulled Jahim off the other woman by his genitals and threw him on the floor. Allegedly, then, Jahim kicked Mary Jane, causing her to fall. Mary Jane and Jahim then both got dressed and left the room. Mary Jane apparently grabbed a bottle of liquor and smashed it on the ground outside the hotel and then sought to call 911. Jahim apparently did not want the police to respond and grabbed the phone and hung it up. When the police responded, they noticed that Mary Jane had suffered injuries to her forehead, her pinky finger, and her pinky toe during the scrum over the phone. Shockingly, no one was arrested in this incident. Mary Jane, Jahim, and the unidentified woman apparently all left peacefully. In just about any other jurisdiction, that would have been a domestic violence call, and everyone would have been arrested, and they would have said, let's have the courts sort it out all later. Mary Jane, although you didn't get arrested, you should have been. And in this particular case, you are a dumb criminal contestant because you agreed to this little birthday bash. It's your birthday. You should get to choose what and with whom you're going to do it. As I mentioned in the introduction, we'll be going live tonight on YouTube as well as Facebook, and you can catch it at 6 p.m. Mountain Time. We will go for about an hour, and after we go live, we will then go to our Patreon group for about a half an hour, which is a much smaller group, and if you have any questions, we will answer them for you. So get your questions ready so we can answer them tonight. We will see you live 6 p.m. Mountain Time on YouTube and Facebook. Thanks for watching Crime Talk, and we'll see you tomorrow.